For omission, item number 1.
Lordship, I am representing the contractor, party number 12 in the matter. I have filed my affidavit, thereby showing the state of the progress what I have achieved. As on date, in one project, my progress is 76%, and in another project, it is 73%. By the 7th of July, I will be able to complete the work.
Is that a reality, or I mean,
It's the reality, Lordship. I am being monitored by the authority. It's reality.
what is the quality of the work?
Last time the affidavit had come and it was in conformity with the standard specifications of the IRC and the mode. And again, the authority will be filing one affidavit. Today, I think today they are going to file it, thereby stating that the test reports are still awaited. The earlier test reports have come and they are in conformity. And subsequently, whatever the works have been taken, they will be filing the test report with regard to that.
May please, my lords. We are yet to receive the NIT report, my lord, testing report. So if your lordship can grant us a week's time, by then we'll be able to file along with all the other lab test report, my lord.
You're for the respondents number 7 to 10.
Yes, my lord, NHIDCL. We are monitoring the project, my lord, the work of the contractor.
What has happened to your earlier chairman of the NHIDCL, who was caught with a lot of...
Money, my lord, in SM. I have no idea, my lord, what has happened.
Look, basically, the work should be completed, but it should be of good quality. What is the maintenance period of the completed work?
It's 3 years.
3 years.
3 years. So when will you file your affidavit?
Within a week, my lord. Once we get the NIT lab report, my lord, then we'll file immediately.
Look, it's when you get the lab report, you have got to act upon it.
Yes, ma'am.
And if it is, of course, bad quality, if the report is bad. Otherwise, if it's good, there's nothing to act upon.
Yes, ma'am.
So we'll leave it to you to decide. But you file the lab report and then we'll release this matter on 13 July then.
Yes, ma'am.
Hopefully by then the project would have completed. Right. Counsel for the respondent number 12, bracket contractor, submits that as on date. The project, which is in 2 contracts, which is divided into contracts, being undertaken by the respondent number 12, are to be completed by 7 July 2026. He submits that one contract, the percentage of work completed is 76% for one contract, while the other is 73%. Mr. Samuel Valarchya for the respondents number 7 to 10 submits that he has not been able to file an affidavit till date with regard to the quality of work being done by the contractor, inasmuch as the test report which has been sent to the NIT
Yes, my lord.
has not been returned. He submits that he expects the results to be received by the respondents number 7 to 10 within a week. The affidavit will thereafter be filed within 2 weeks. List the matter on 13/7. Ms. Emily, that's all I think.
Yes, my lord. The thing is that, my lord, the roads are being repaired, that is there, but there seems to be potholes and all in the Kamrang stretch, As-
There are potholes in the Kamra stretch.
as per the reports.
In
that we
the
have-
already constructed roads.
Yes, my lord.
In not our section.
Not their section.
No, not in my section.
Okay, though the counsel for the petitioner submits that there are potholes in the Kamrang section of the repaired roads,
Yes, my lord.
the counsel for the respondent number 12 submits that the said section where there are potholes would not be within the contract work being undertaken by the respondent number 12. In this regard, Mr. Samuel Waller, in this regard, the counsel for the respondent number 7 to 10 shall conduct a survey and make a report with regard to whether there are any potholes in the Kamrang section of the Sairang to Kanpur Road, and inform this court as to what steps are being undertaken by them to ensure that the contractor repairs the road where there are potholes. Then don't list the matter on, don't say 13th, list the matter on today's 10th.
10.
This is the matter on 24th. You 24th of June. You see, you please ensure it's your job.
Yes,
Since you have said this.
Obliged.
Highly obliged.
Item number 2.
Yes, Lordship, I have received the affidavit submitted by the state, BRTF, who were newly implemented since the road has been taken up between Aizol, Kolosip, Silchar via Durtlang Road.
So what remains?
Yes, Lordship, as per their affidavit, it is stated that it has been handed over to PWD NH Division 3 on 31st March 2010 by 107 RCC.
So they've got nothing to do with it. What do you want right now in this PIL? Which roads now are you dealing?
We have mainly concentrated on the 4 stretches of road, Lordship.
Which are the 4?
Only the 4 stretches of road.
Which 4 stretches?
The 4 stretches are, Lordship. The first one is Aizol to Kolosip to Silchar. This is via Durtlang Road. And the second one is Aizol to Kanghun via Mamit.
Aizol to Kanhun.
Kanghun, yes. This is via Mamit Road, which covers 189 kilometer. Then Lunglei to Tlabung Road. And the fourth one is Lunglei to Chongte Road. These are the 4 stretches of road which we have emphasized, Lordship.
And what is the report on those 4 stretches?
So far, MPWD, NHIDCL, and BRTF, they have been blaming each other, mostly, Lordship.
No.
That these stretches of road has not been taken up by us. It is handled by MPWD. Some of the NHIDCL stated that it has been taken up by state PWD. So this mixed control, which has caused coordination issues.
No, tell me one thing. The Aizawl Durtlang Silchar Road.
Yes, Lordship.
Now, where is the bad patch?
This is mainly between Kolosip to Silchar, Lordship. The Mizoram site has been taken up by
Okay,
MPWD.
And so it is between Kolosip to
Silchar.
where is the Silchar?
Yes.
Now tell me, so with regard to till Korpui, you have got no issues.
No, not much, Lordship, except
What do you
for
mean
some
not much?
potholes. We have furnished a recent photographs, but it has been repaired, but it doesn't last one season. That is the main problem,
That is a
Lordship.
different aspect. That is a different aspect. I can tell you in some state, and one state in particular, the roads last only for a particular uh, festival period.
Not even for the whole season.
Not really for the whole season, just for the festival period. So, you see, those are different aspects. You cannot have everything under the sun. Now, Kolasip to Warengte, who is the authority to, who is looking after that? You're for who, madam? You're appearing for whom?
Yes, Lordship, I'm appearing on behalf of respondent number 6,
Who is that?
BRTF, on
BRTF.
behalf of my senior CGC.
Huh?
On behalf of my senior CGC.
Yes, Mr. Aforesaid. You're appearing for whom? Then what about PWD? If PWD is there, then what happened? I think you've got you'll be having a problem.
The stretch of
You cannot be the AG and also the representing NHIDC. There's a clash. No, that's a different thing. The supervising authority is whom? You see, you have got to see whether, I hope there is no clash of interest. Yes,
Your Lordship, the stretch of road between Aizawl to Konpui is maintained by the BRDF, and
but then they have said no.
Sipir to Durtlang is maintained by Mizoram PWD.
See here too.
Sipir to Durtlang and Kolosip to Silchar Road is maintained by the NHIDCL.
NHIDCL.
Yes, Your Lordship.
Okay. Silchar to, then you're the, what is the status of Silchar to Kolosip to Silchar?
Lord, in terms of the last order dated 13/5/2026, my lord, we were supposed to submit the up-to-date status of all the roads that have been mentioned in the PIL. So we have directed all the PMUs to submit all the status report
Yes,
altogether.
they are not doing it, so what to do? Then we haul up your boss. We cannot do your job for you.
No, my
Either
lord,
you do
we are
your job
waiting
or
for
we
all the reports from all the PMU, my lord.
This is a month ago, Mr. Council. 13/5.
Yes, my lord.
How much time do you need now in this day and age?
Because
they have-
earlier our work progress we had submitted, it was 5 months back, my lord. So the up-to-date status, we are making inquiries and getting all the information from all the project management unit, my lord. Once all the information comes in, my lord, all the different roads that has been entrusted to NHIDCL, we can state all the progress of the work. my lord.
Who is doing the work between Lunglei and Tlabung? I don't know. Nobody goes down. No train is there. Only the trucks will go down.
is currently maintained by NHIDCL, Lordship, Lunglei to Tlabung. As I have mentioned in para 7
Is
on
it
page
recorded in
22.
any of these orders? Right. Miss Rosalind Elmar, learned counsel for the petitioner, submits that yes, it is there. Order passed by us is here. It is in fact in 21-126. The four roads are here, mentioned here. Yes. Look, you come to the order dated 21-1-2026. It was in January, this court had passed this order. Where is the BRTF affidavit? I mean PWD affidavit? Twenty-five 3. I have got 121-26. Wait. 25 3.
Yes, Your Lordship, in compliance to the order
All
dated
21.
21-1-2026.
Just show, just let me see. This is 25 3, yes. You have not made a mention of Lunglei Chongte Road in your affidavit, madam.
Lordship, it's there at para 3.
Pantry.
Yes, Your Lordship. Lunglei to Tlabung, and at the second para, Tsum Kum to Zongte.
Work order was also issued on 5/6/25. You give a status report within 2 weeks,
Yes, Your Lordship.
or otherwise, you take it seriously. Lunglei Tlabung is under NHIDCL. Then
Taken up by us.
no, we want to know the status report.
We're awaiting that from the PMU, my lord, from all the districts, my lord. With the
We're not concerned with all the districts. We're concerned with only 4 stretches of road.
Yes, ma'am.
You bring that you bring the information with regard to these 4 stretches of road.
Yes, ma'am.
You file it within a week, both of you. Right. The present petition is with regard to the maintenance of 4 stretches of roads within the state of Mizoram, that is number 1, Aizol Kolasin Silchar Road via Durtlang. Number 2, Aizol to Kanmun via Mamit. Number 3, Lunglei to Tlabung. And number 4, Lunglei to Chongte Road. Next. The counsel for the petitioner submits that the road condition between Kolasib to Vairagte to Aizol to Silchar is under the PWD and is in a very bad condition. What's up? With regard to, next para, with regard to the Aizol to Kanmun via Mamit Road, the affidavit dated 25/3/2026 issued by the state respondents number 1 to 5 is to the effect that a sum of rupees 8 crores was issued, had been sanctioned for restoration of damages, and work order was issued on 5/6/2025, and that the restoration work was going on, which would be completed before the coming monsoon season. Next para. With regard to the Lunglei Tlabung Road, the affidavit of respondents number 1 to 5 is to the effect that the same is currently being maintained by the NHIDCL. Next. Wait. Come here, look, 8 crores. That will be with regard to Lunglei Chongte Road. Okay, Lunglei Chongte. With regard to the Aizol to Kanmun via Mamit Road, the affidavit of the respondent numbers 1 to 5 dated 25/3/2026 states that the Ministry of Road Transport and Highways had sanctioned the sum of rupees 170.96 crores on 8/10/2025, and tender was floated for the work. The work is to be completed within 24 months. Full stop. Next para. On considering all the above, the NHIDCL shall submit a report with regard to the before that, with regard to that, no, come on. I resolve to Silchar Road. Just one more paragraph you just read. The affidavit of the state respondents dated 25/3/2025, 2026 states that the stretch between the stretch between Bidkhotlir and Kolasit had been handed over by the National Highway Division Roman 3, PWD Thingdor, to NHIDCL on 7/7/2025. Full stop. Next, on considering all the above, the NHIDCL shall make a report with regard to will make a status report with regard to the stretch of road between Lunglei and Tlabung and between Bilkhotlir and Kolasit. Full stop. Next para. With regard to the Aizawl to Kanhun via Mamit Road, the PWD shall give the name of the contractor to whom the work has been allotted and the time of completion of the same. Status report with regard to the above should be given. Next para. With regard to the Lunglei Tlabung Road, the NHIDCL shall give a status report. With regard to the Lunglei Chongte Road, the PWD shall give a report, status report. All the above status reports should be submitted by way of an affidavit within a week. List the matter on 17th.
Obliged, Lordship.
Item number 3.
Appeal is dismissed.
Deeply obliged.
I seek your lordship's indulgence in mentioning item 1 of part 2, my lord. My lord, the leading counsel, Mr. A.R. Malhotra, is unable to attend the court today
Why?
due to the bereavement of his sudden bereavement
Oh,
of his
in Darpat, yes.
my lord. So if this matter can be listed after a week.
My lord, I don't know, it's up to the court, my lord. Anytime, we could have taken it up today also, but since he's not here.
No, he's, what to do with the
Yes, what to
bereavement? There's a bereavement in his locality,
Yes,
as much I
yes.
know. So it is, you know that step going up,
Yes, yes.
that thing, so they are on this side of the steps.
Yes. No, I have
So
been
that'll be
informed by
pretty
him. Malhotra said he was his Sunday school student.
That disease, his father was a friend of ours also, a long time. Not Malhotra's friend, because Malhotra is slightly younger, but our friend. Anyway, 35-year-old. 35-year-old.
Yes, 35.
What to do?
My lord, we can do it, my lord, immediately after the vacation also, if it's possible.
I don't know. Depends upon your.
My lord, can it be listed after a week?
After a week. Okay, list the matter on 1st July.
1st July, yes.
List the matter on 1st July. On the prayer made on behalf of Mr. A.R. Malhotra.
Obliged.
Why should it be 1st July? It's in the hearing list, no?
It's in the hearing list.
And the week commencing from 29 June.
Obliged.
Or you say 1st July, it's okay. Let it be.
If the date could be fixed.
1st July, 1st July. Then on the prayer made on behalf, same point, huh? On the prayer made on behalf of Mr. Yarmo. This is the matter of 1st July. Yes, next.
Item number 1.
Sorry, my lord, 1st July, I have one matter. So, my lord, is it possible to do immediately after the 1st July, that week? Sorry, my lord, there's a vacation there, so on the
You can do it a second.
2nd, my lord.
Lordship, with apologies, I would like to submit that the petitioner could not submit the check
Your
amount.
check bounced, Mr.
Yes, it is
Counsel.
bounced. So, my lord,
It's not that you could not submit your check bounced.
yes, it is bounced. So, I have inquired about that from him, and I have asked him to.
Your bona fides is doubtful now, Mr. Counsel.
In fact, Your Lordship, he also deceived me, because I told him clearly that you have to do it, and he said that yes, there is a fixed deposit against which the check was issued to me, and I handed over to the registry as per his instruction, and I had made a forwarding letter as well, but I have been told that it was bounced. So,
Yes,
my
it is
lord,
bounced.
yes, I asked him what is the reason. He said that it is put as fixed, so it cannot be released. That is what the bank said.
He can always break the.
Yes,
the
that is
fixed
what I
deposit.
suggested, my lord. He said that there are some problems. When I asked him to get it from the other source, and he said that if he could be given some more time, so I seek a lot of indulgence to give him.
Let him
at
deposit
least-
the fixed deposit here.
or at least if he could be kindly given another at least 7 days time. So in the meantime, let him try to get it from the other source. That is what he told me. This morning he called me. I seek for your lordship's indulgence. my lord.
First of all, it has bounced.
That is, I explained it to him that you
And
can
it
face the
says
criminal.
here, it says here, due to insufficient funds. If he was having insufficient funds, why did he submit a check to the High Court?
I scolded him as well, your lordship.
No,
Telling him
scolding will not do, na. He needs to be taught a lesson.
He also deceived me, in fact, your lordship, although he is my client. And I told him that I'm not happy with what he had done. But he prayed for.
When is the fixed deposit going to mature?
My lord, that I have to inquire.
You talk to him, you tell him, ask him to deposit the fixed deposit here. At the time of its maturity, we'll take the amount that is required and we'll give him back the rest. Talk to him. We'll
Alright.
take it up after you talk to him.
Okay.
Item number 2.
Your Lordship, I have filed the rejoinder affidavit this morning. I have served copy to the other parties as well.
Oh, yes, so what is to be done here?
If it may be taken up again,
Mr.
some other
Malhotra,
day.
my lord, is
Huh?
also, Malhotra is also a party. It's a councilman. I mean,
Anyway, so this is the issue, you see. You're for who, Mr. Biraramaya? You're for?
I'm for the petitioners, my lord.
And Malhotra is for? Respondent members. Anyway, this is the issue with regard to damages.
No, Your Lordship, this is challenging of the appointment of respondent number 5 to the post of Assistant Registrar, NIT.
Item?
Item 2.
Item 2, you had asked for adjournment.
Oh,
I think, no? Someone had asked for
this is
adjournment.
part 1, my lord.
Part 1. Oh. Oh. There was a,
My lord, the earlier adjournment was regarding part 2, item number 1.
oh, okay. Not this matter. Oh, I thought this matter. Okay. So this is different. Assistant registrar. Okay. So what to do?
It may come up some other day, my lord, for.
Because Mr. Malhotra
Yes,
is not
yes.
here. Right. As Mr. Malhotra, A.R. Malhotra is not available due to family, due to is not is due to personal difficulty. List the matter. When?
After vacation, my lord.
Why? 2023 matter. We'll do it before.
Then
anytime, my lord.
in the first week of July.
List the matter on
First July.
no. List the matter on 29th June. 29th June. Then there's 1 day holiday. Okay, 1st July. 1st July.
Much obliged.
Item 3.
Lordship, I'm appearing on behalf of respondent number 7, newly implemented respondent, Ministry of Environment, Forest and Climate Change. May I seek 2 weeks' time for filing affidavit in opposition?
Yes, Mr. Victor, why don't you go for civil court? Damages. How is this writ petition? How are we going to decide what is the rates and all? Evidence is required to
My
be
lord,
taken.
perhaps it may depend on the response of the Ministry of Forest, because the disposal of confiscated items is under the instruction of the ministry. So having them implemented as a party, my lord,
Is
we
required.
may wait for the response.
Miss,
Bilal Din Zwali,
appearing for
respondent number 7,
is granted
2 weeks' time, my lord.
only.
If possible, 3 weeks.
Is granted 4 weeks time to file affidavit in opposition. This is the matter of 4 weeks. Your first time, no? Applying. Oh, no. Oh, I thought you applied for the first time.
First time.
First time
They were
applying.
recently implemented as a party.
Okay, first time, so that's why.
Item 4.
4 weeks.
Please, Your Lordship. Lordship, appearing on behalf of Messinia, Mr. C. Ramzawa, we have filed rejoinder affidavit this morning,
Okay.
and we have served copies to the respondents as well.
Yes, so what is the matter about?
Regarding non-payment of interest installation,
Yes, so
so we are seeking for that payment, interest installation.
okay, start.
So if this matter may be, Lordship, if this matter may be taken up after a week,
After a week. Right, on the paper, Mr.
Sila Ramzao. My name is Stephen Lalbuatse.
Stephen Lalbuatsaya, appearing for Mr. C. Ramzawa, learned senior counsel for respondent number.
Petitioner.
For the petitioner, submit the rejoinder affidavit has been filed today. On his prayer, list the matter after a week.
Item 5.
My lord, if this matter can also be
Okay,
listed
right.
after we-
Adjournment prayer has been made on behalf of Mr. A.R. Malhotra due to a death in the locality, in the Zarkot locality. Full stop. Accordingly, list this matter when?
17, Your Lordship.
17. This is the matter on 17.
Item 6.
No one appears for the petitioner, while Miss Mary L. Kempe, APP, appears for the state. You are appearing here? Oh, okay. What is your case?
My lord, I would like to withdraw this case, my lord. There is some technical error, my lord.
Very much.
Yes, my lord.
Lot of false statements have been made. Correct?
Yes, my lord. I believe so.
Yeah, you're good that you are full of false statements. Now it's for plaintiff evidence. Do you know that? The
My
next
lord,
date is fixed for 18 June.
there is some confusion regarding that, my lord.
No, it is there. I've got the records. I've seen the records.
Lord,
You have said that you have not even been given the papers till now, charge sheet. You have got the papers here. The photocopies. I was finding it quite funny, and I was not believing what you were saying here. Charge has been framed on 10/5 already. Yeah, I've got it signed.
10-5.
I was going to impose heavy cost upon you. Good. Mr.
J.S. Ricky Lalrothfela.
J.H. Ricky Lalrothfela, appearing for the petitioner, prays that he may be allowed to withdraw the bail application as some of the averments made therein were not correct. Miss Mary L. Kempe, APP, appears for the state on account of the prayer made by the petitioner's counsel. The petition is dismissed as withdrawn.
My lord, liberty to file afresh, my lord.
That's always there. There's no, you can file it 1,000 times also. That doesn't matter.
Yes, my lord. Obliged, my lord.
Item 7.
Please, Your Lordship, this is an application for implement of the new incumbent of state engineer.
Yes,
PRTF,
any
as
objection?
respondent number 8 in the connected.
Yes, madam, any objections?
No, my lord.
This is an application for implement of the new chief engineer of project Pushpa as a respondent number
8.
8. Miss Baby
Laldin Zwali.
Laldin Zwali, appearing for
Respondent number 2.
respondent number 2. Anybody else?
For respondent number 4, and I'll be filing my power on the
Come on, Miss Mary L. Khyante, for respondent number 4. 7. 7. Who submits that she will be filing her Bakarat Nama within a week. Okay, for 7, for 7. So appearing for number 7, and Ms. Lal will be appearing for
Respondent number 3, Your Lordship.
respondent number 3. Submit that they've got no objection to the prayer being allowed. Accordingly, Dr. Crash Nendra Singh, the Chief Engineer, Border Road Task Force, BRTF, bracket, Project Pushpak, GREF, care of 99 APO, is implemented as respondent number 8. Registry to, applicant petitioner to submit corrected copy of the cost title to the registry within 2 days. Within 2 days.
2 working days, yes.
Within 2 days. I is accordingly disposed of. Then in the main appeal, you write, main contempt, you write, in view of the order dated 10/6/26 passed in IAC number 112 of 2026, Dr. So-and-so is implemented as respondent number 8. Issue notice to the respondent number 8. Petitioner to take steps for service of notice upon the respondent number 8 by speed post and usual mode within 3 days, 2 days.
My lord, after that will be after making the amendments. So
You can do it
within
together.
1
No?
week.
You can do it together. Doesn't matter. That is the registry problem.
Yes, ma'am.
Within 2 days. This is the matter. After review, after vacation.
14 July.
Deeply obliged.
I is disposed of. Acha, in the main contempt you also write, Ms. Mary L. Kente, counsel for the respondent number 7, submits that he will also be appearing for the respondent number 4. Full stop. He submits that Vakalat Nama will be submitted in respect of respondent number 4 within a week. In the course of the day, during the course of the day.
Much obliged.
Item number 8.
Wait, no? Yeah. This is yesterday's matter. No.
Yes, Lord. Yes, Lord. There was an issue with respect to LA plan.
LA plan.
LA
yes.
plan. What does it shows, ma'am? May please refer the last page.
This.
Malad, below the second half of the page, Malad, the second last building from the second last plot from the right hand side, which says PP 501 10 208/2004.
Yes.
That is the periodic patta number of respondent number 1, Malots. Malots may see it is written KRKR. Just before the PP starts, KRKR.
KR.
Malot, that shows 2 numbers of building on the land of periodic patta. Respondent number 1, Malots.
Yes.
My lords, this is a manual of guidelines on land acquisition for national highway under NH Act issued by the Ministry of Road Transport and Highway Government of India. My lords, the present issue pertains to the construction of land. Their claim is 5 buildings, whereas Kala awarded 3 buildings. Now, which has to be considered? There is a guidelines for Kala. So, my lord, I would like to directly take you to the relevant page number, my lords. My lords, the internal page 190, which is fourth last page. Point number 10, my lords.
Yes.
My lord, point number 10 is competent authority for land acquisition, Kala, and due diligence at the time of determination of compensation amount by the competent authority.
Yes.
My lords, the relevant para is serial number 4, my lords. Next page. My lords, I'll just read this. This will clarify why 3 was considered and 2 were left out, my lords. It may further be noted that the market value of land is to be determined as on the date of publication of preliminary notification under 3A of National Highway Act 1956. It is for this reason that in addition to the market value of land and solatium, the landowner is also paid an amount calculated at the rate 12% per annum from the date of initial notification under section 3A till the announcement of award or possession of land, whichever is earlier. Instances has come to notice, my lords, please may note this, where the landowner interested party have undertaken certain improvement over the land notified under section 3A after the publication of notification in order to enhance the quantum of compensation, my lords. This would include plantation of tree on such land to add the value. As such, Kala are duty bound to ignore any improvement done over the notified land after the date of notification while determining the compensation amount and announcing the award under section 3G of National Highway Act. So, my lord, it came to the notice of Government of India that what has been happening after this 2013 Act, that once the 3A notification is out, the landowner used to construct some building over the land in order to get enhanced compensation. So they have clarified that the date of land, the valuation of the land has to be done on the date of.
But you did not bring out all these issues earlier.
Well, our whole issue was that the learned arbitrator has included 2 buildings without any evidence. Kala has excluded 2 buildings based on land.
This is only with issue of structures or also with
enhanced value also. Both issues are there in this matter.
Should we send it back? I think so.
My lords, may send it back with respect to structure because, my lords, enhanced valuation was based out of no reasoning, my lord. If there would have been any substance to that, so, my lord.
No, we'll do it on the basis of the records already there, and also on the basis of yes, because that issue of enhancement cannot arise now, because that there's already a decision in one matter. But with regard to the structure, let the arbitrator take a fresh decision.
May please, Your Lordship. Regarding the structures, I think Your Lordship has already made up his mind yesterday. And it says that my learned friends have no case in this instance. Regarding the structures, now I think we should fixate our attention regarding the market value of the land.
No, everything is under consideration. There's no real decision. You see, because one thing, now, the thing is that as per this what is this called? Land acquisition plan.
Manual of guidance on land acquisition.
No. This drawing, this land acquisition
plan. Yes.
In this land acquisition plan, And it appears that there are only two structures.
My lord, my learned friend should be happy that your lordship even allows him to bring this alia plan at this stage. Your lordship has rightly said all these issues should have been raised earlier before the arbitrator. And this issue was also never been raised before the Section 34 court. It was never there. And other than that, even though
They're never
is-
there.
My lord,
Yes.
the issue was there, but my lord will be surprised to note that despite the issue and even the under section 34, our submission is recorded in the order, but the learned judge has not taken into consideration the issue with respect to two structure. He has only elaborated the issue with respect to rate.
You have not submitted any written pleadings, I think, before
Yes.
before the arbitrator.
No, my lord, not before the arbitrator. But my lord, Kala has submitted.
Kala is submitted.
Kala submitted.
And Kala submitted stated what? Stated what?
Stating the same thing, that as per the LA plan drawing, he has excluded the two buildings, and the three were included and two were excluded based on the LA drawing. He also submitted that
In your section 34 application, did you take this point? Where is your section 34 application? Yes. This is your section 34.
Yes. My lord, the pagination are not done. My lords, para number 21 is the grounds. I'll directly come to the grounds, my lords.
Yes.
My lords, ground C, that the reasoning of the learned arbitrator in para 10.9 of the award to enhance the compensation, and in para 8 of the award directing Kala to make an assessment of the remaining two structure as per PWD SOR 2019 are without any basis in law or fact and are conjectural, which render the said part of the award virtually unreasoned and liable to be interfered by this honorable court.
This is still a very broad submission, my lord. They did not bring out this LA plan map, the issue of this LA plan map, before the Section 34 court.
My lord, section 34, the learned judge has not gone into this issue at all. My lord, I'll just refer to the order passed by section 34 judge, my lords. My lords, the appeal book, page number 18, my lords. Page number 18 of the appeal book.
Which appeal? The present appeal?
Present appeal, my lords. Page number 18.
Yes.
My lords, I'm reading para number 21. Before,
Yes.
above para number 21, it's all the submission of all the parties, my lords.
Okay.
In my considered view, enhancement of market value of land belonging to the respondent by taking into consideration the prevailing market value of land within the district based upon relevant sale deed, the location, peculiarity, inflation of price, and location advantage of the land belonging to the respondent is not against the natural justice and is found reasonable. It is opined not only contrary to the substantive law and not against the public policy of India. Considering the above observation made by this court and by placing reliance upon the law that has been laid down by the Honorable Supreme Court in India in the cases supra, this court find no reason to interfere with the arbitral order dated 14/6/2024 passed by the learned loan arbitrator in arbitration case number this.
Oh, oh, oh. Okay,
No.
it's 1 o'clock.
Yes. We can continue, my lord.
Hmm?
We can continue after 2.
Yes.
Yes.
Before that, the bail application, we'll just dispose of the bail. The next item. We'll just do the next item.
Item 9.
Just so that they don't have to wait.
The learned PPs, my lord, I think they're in the-
Pass over. Yeah. Yes, what is to be done?
My lord, this is a bail application. The petitioner herein was arrested on 23/7/2022 in the case number 34 of 2022 involving an alleged recovery of 836 grams of heroin from his possession. And he initially filed a bail application which was rejected before this court. And subsequently, he filed another bail application and which was granted on 13/10/2023. During his enlargement on bail, the petitioner, due to an alleged violations of the bail condition, he was arrested again on 26/9/2025, which was registered as PS case number 34 of 2022 at Sampai. And after he was
Okay,
arrested,
who is for the PP?
she has gone up.
We'll take it up at 2 then. At 2. Okay. I have one thing. This notification 27. Call this.
My lord, the BP is here.
We'll take it up at 2.
Was arrested in Aizawl, and the second one was
No,
arrested.
no, what are the case numbers?
Case number.
First one is, what is the case number?
First one is NDNPS case.
PS case number
PS case
or
number
excise number?
34 of 2022.
Huh?
And
PS case number, is it which police station? Police station or what?
NDNPS, narcotics,
Caught by police or by excise?
excise.
Excise. So what is the case number?
That is PS case number 34 of 2022.
It don't say PS. It is special narcotics PS.
Yes, Your Lordship.
You see, there is a police station case number always. So special narcotics PS case number 34 of 2022. In this case, how much? What was the amount of seizure?
It was 836 grams of heroin.
836 grams of heroin. So you were granted bail.
Yes,
When?
Your Lordship. It was on 19. The bail was granted on 13/10/2023.
13/10/23.
Yes, Your Lordship.
Then you were arrested.
He was again arrested on 04/07/2025.
Just a minute. 4/4/25.
4/7/2025.
4/7/25. In which case?
Case number 52 of 2025.
What police station case number or what?
Champai
it-
PS case.
Huh?
Champai PS.
Champai PS. Champai PS case number
52 of 2025.
52 for how many? What is the seizure amount? What was seized?
Of heroin.
How much? Quantity?
Your Lordship, I'm not aware of this case because we are
What
not
is the
engaged.
case number? What is
The
the case
case number
number?
is 52 of 2025.
And
but I'm not
Under which section?
under section 22C, 25 and 29.
Under section 22C
Commercial.
and 25, commercial quantity,
Sir, Lordship.
methamphetamines, 22, psychotropic substance, sorry. Huh? Then you are arrested.
Yes, Your Lordship.
Now there is another case against you, is there?
Yes, Your Lordship.
What is the case number?
The case number is 52 of
Which
2025.
police station?
Champai Police Station.
Champai PS case number what?
52 of 2025.
No, besides that, there's a third case, no?
No. There's only two cases.
Only two cases, are you sure?
Yes. At the time of his arrest, again on 4/7/2025, his previous bail was cancelled. Because of that, this bail application is filed.
Okay, so there are only two cases against you.
Yes, Your Lordship.
So you were arrested in this Champai PS case 52, and that's why your bail was cancelled in the earlier one also.
Yes, Your
Correct.
Lordship. Yes, Your Lordship. So, my main contention is that in the rejection of bail in the lower court, it was stated that he has allegedly violated the bail condition by stating that he absconded.
No. The thing is that while you were on bail, you are involved in a similar crime, similar offense.
Lordship.
What is wrong? Let us see the impugned order.
It is at page 63.
Page 63.
Yes, Your Lordship.
The roster has arrived, I think. I don't think Justice, I think this matter, I think Justice Budi had given you the bail.
Yes, Your Lordship.
So you are asking bail again on that same thing, on that same case.
Yes, Your
So you
Lordship.
should go to him.
Uh,
As per the notification number 27 of the Gauhati High Court dated 3/5/25. It has to go to him. Otherwise, Chief Justice will have to uh, allow this court to deal with it. But it's better that I don't deal with it. You probably will not get what you want. Because you have done a similar case while out on bail. There was a commercial quantity. Right. I heard Miss
Lalmingyani.
Learned Counsel for the petitioner who prays for bail. In Special Narcotic PS case number 34 of 2022. What is the charge sheet has been filed here?
Yes,
Yes,
Your
Your
Lordship.
And what is the stage of trial?
As,
Plaintiff evidence.
Huh?
Plaintiff evidence.
Plaintiff evidence?
I'm sorry, prosecution evidence.
as
What is the GR number?
GR number is,
Full stop. He submits that as charge sheet has been filed, comma, the case has been renumbered as what? Has been registered as?
no, it's the same number, Your Lordship.
can-
Actually, in the petition, they did not mention exactly
What is the
has
case
happened.
number before the trial court?
34 of 2022.
That is the narcotic police station case number, madam.
Your
Trial-
Lordship, we are filing the same, the bail petition on the
On the basis of
the previous case. We are not disputing the 2025 case.
2025 case?
Yes, the subsequent arrest.
I'm not on that, madam. You see, this is a police station case number. When it goes to the court, after filing of charge sheet, then there is a new case number given by the court. It has to be there. That is the.
Yeah.
You ask all your senior counsels, your colleagues or the senior colleagues, they'll tell you that the police station case number will have a new, I mean, it will remain, but then a court will give you a new case number. You don't know. Yeah, right, whatever I said. Charge sheet has been filed. She submits that charge sheet has been filed and that the case, the stage of trial is for prosecution evidence. She however submits that she does not know the case registration number given by the trial court. Full stop. This case, this The brief facts of the case is that the petitioner was arrested by the excise personnel on when? When were you arrested initially?
Initially, he was arrested on 4/7/2025.
On 4/7/2025, in connection with the recovery of 836 grams of heroin from the petitioner. And pursuant to which Special Narcotics PS case number 34 of 2022 was registered. Next para. Why? No, the petitioner was granted bail by the learned trial court in Special Narcotic PS case number 34 of 2022 on which date were you granted bail?
23/7/2022.
23/7/2022. However, while on bail, the petitioner was arrested in connection with the seizure of methamphetamines. Correct? In connection with psychotropic substances, seizure of psychotropic substances, for which Champai PS case number 52/2025 was registered under section 22C/25/29. Correct? 29 is also there, should be
Yes,
there.
Lord.
NDPS Act. On 4/7/25, arrested on 4/7/25. Next. Due to the above arrest of the petitioner in Champai PS case number 52 of 2025, the bail granted to him in Special Narcotics PS case number 34 of 2022 was cancelled on
26/9/2025.
26/9/2025. Full stop. Next para. The petitioner is now praying for bail. In which case are you praying for bail? In both or what?
Only for the previous one, that is,
In Special Narcotics PS case number 34 of 2022. Full stop. Next para. In view of the fact that Honorable Mr. Justice Budi Habu had granted bail to the petitioner. Correct?
yes, Your Lordship.
In Special Narcotics PS case number 34 of 2022, while order dated 13/10/23, in bail application number 45 of 2023. It might not be proper for this court for this bench to take up the present bail application in view of notification number 27 dated 3/5/25 issued by the Registrar General of the Gauhati High Court. What we can do is we can ask you can either wait for, but the problem is, now Supreme Court direction is that the bail application should be disposed of within 2 weeks, I think. You've got the judgment?
Yes, Your Lordship.
Show me the judgment.
I don't have it with me right now.
But there is a judgment, correct?
Yes, Your
In
Lordship.
view of the fact that the roster provided for the Aizol bench does not have a bench of Justice, Honorable Mr. Justice Budi Habu for the whole of this month and half of the next month. The the matter may be brought to the notice of the Honorable Chief Justice, keeping in view the fact that bail applications are to be decided within a period of 2 weeks, I think. Is it? I think there was an order. Listen. I think there was an order. Anyone who knows that order? Okay, then that's all. Huh? I'll make the correction necessary changes. Okay, I'll just read the orders and all. Then, if we place it before the Honorable Chief Justice, or we'll have to do it by VC or something. We'll see.
Lunch.
Pass over item 1.
Your Lordship, I have spoken to the concerned branch manager of Yes Bank where fixed deposit was made. Since the petitioner informed me that he misplaced the certificate of fixed deposit. So I have confirmed through phone call that I have placed before Your Lordship, my Lord, this is the screenshot copy of the detail of the fixed deposit. The account number is there, I have highlighted it, my Lord. And the amount is there. It will be matured only on 24th October 2026. And the branch manager told me that the fixed deposit certificate could be issued again in favor of the petitioner if necessary.
You mean after breaking it?
Even at this stage also, my Lord.
Okay.
So it can be, if it is attached or I don't know whether...
No, why should we attach?
Attach in the sense that,
the
my
only
Lord,
thing is,
we'll deposit it, the petitioner will ask again for the copy, another copy, and it will be issued.
You can break it up into two deposits. Oh no, it cannot be done.
Since it,
then he'll lose his interest.
And I have placed one registration certificate of this tipper vehicle also, my Lord, if necessary.
No, we don't want to. We don't want
Yes.
vehicle. Where will we park?
I'm talking
We
about
just
security.
want the money. That's
Yes.
all. So
So
you talk to him.
My Lord.
Is he ready to deposit the fixed deposit here in our court?
The branch manager told me that this is connected to the contract work, due to which the PWD department has also has to grant some.
So your client is basically a bit too smart.
I think he's not smart enough to understand all this. Like, I don't know how to release the amount also, my Lord, because I told him several times that you have to get it from the other reliable source because it is the order of this Honorable High Court. But still, he's saying that he will sell the excavator. Now he is trying to do it. And from that, if necessary, he will get the money, and if necessary, he will deposit it. That is what he
Okay,
said.
we'll give you 1 week, you do it.
My Lord.
Right. Heard Mr. B. Lalamaya. Have you taken steps? Achha, we have not issued notice, no?
Yes, my Lord.
We have issued notice.
My Lord, I'll do it today itself.
You have not taken steps also.
My Lord, I'll do it today itself.
Heard Mr. B. Lalamaya, learned counsel for the petition. The matter pertains to a challenge to the award passed by the Lok Adalat on the ground that the petitioner had not signed the settlement agreement and that his representative had signed the same without his permission. This court, while issuing notice on 2/6/2026, had directed the petitioner to deposit rupees 8.2 lakhs in the registry of this court within a week from 2626, in view of the fact that the petitioner had admitted to having a liability of rupees 8.2 lakhs payable to the workers, which included the petitioner hearing. In terms of the order dated 2/6/2026, the petitioner had submitted a Yes Bank check number 824417 for an amount of rupees 8.2 lakhs on 3/6/2026. The same had been forwarded to the branch manager SBI Dorpuri branch, Aizol, for placement in a fixed deposit by the registry of this account, by the registry of this court. However, the check was returned due to insufficient funds. The petitioner's counsel submits that there is approximately rupees 13.98 lakhs in the account of the petitioner, which is also payable to the PWD.
No, my lord, it is with the consent of the PWD. It has to
Which
be.
has to be paid with the consent of the PWD. Full stop. So PWD may be required to be a party here also. Full stop. The petitioner's counsel submits, next para, that he may be given a week's time to make alternative arrangements to make payment of rupees 8.2 lakhs. Full stop. On considering the submission made by the petitioner's counsel that the fixed deposit of rupees 13.98 lakhs put in a fixed deposit and which is payable by the petitioner with the consent of the PWD. This court is of the view that the PWD should also be made a party to the present proceeding. Just may be required to be made. May be required to be made a party to the present proceeding. This is the matter on
2nd July was already fixed, my lord.
No, huh?
2nd July was already fixed in.
No, that was because we thought you will pay the amount.
Yes.
Now you have not paid the amount. This is the matter on 22/6 to enable the petitioner to deposit rupees 8.2 lakhs from alternative sources in terms of the order dated 1/6/26.
My lord, it may come up on 23rd. Please.
23rd.
Much obliged.
The petitioner's counsel also submits that he will take steps in terms of the order date, take steps for service of notice upon the respondent in terms of the order dated 2/6/2026 today.
Much obliged.
Item 8.
My lords, with respect to the inclusion of two buildings, my respectful submission is that 3G award was passed and Kala intentionally excluded the two buildings on the premises that following the guidelines of the Government of India, he has to include only those buildings that existed on the date of 3A notification. And he relied upon a 3A plan map which shows that only the two buildings that has been excluded were not there a part of a 3A plan, and have judicial, with the application of mine, he has excluded those buildings. Now, my lord, the burden of proof that those two buildings existed on 3A notification was upon the respondent herein, and they failed to prove before the learned arbitrator that those two buildings existed. Even thereafter, the learned arbitrator granted the inclusion of these two buildings. And to challenge that, we have gone before 34 and we are
No,
here.
learned arbitrator has approved, has agreed to that thing. That's why he has paid.
My lords, the basis for agreement is arbitrary, my lords. My lord may come to may please refer, my lords, page 229, my lords. 220, my lords.
Yes.
My lords, para number 7 tells how the learned arbitrator has included the building. The outcome of the spot verification conducted pursuant to the interim order dated 4/12/23 is that 5 structures were actually standing. My lords, the spot verification nowhere says that. My lords, may please refer the spot
We're
verification.
actually standing. Yes, let us. Where's the spot verification?
My lords, yesterday we have served a copy of spot. My lords, I'll serve it.
Uh-huh.
Yesterday,
You see, you are giving me papers after papers after papers.
my
This
lords,
is not the
this
way.
copy has been given yesterday also.
Maybe. That is why I cannot keep track of all the papers that you give. This is not the way to do things. Everything should have been in the records by now. You cannot, can you make up a case now at this stage?
This was a record of the learned arbitrator, my lords. My lord, para number 3 is relevant on the last page.
Yes.
On arriving at the site, 5 structures such as Assam type with RCC flooring, go down RCC flooring A, go down RCC flooring B, go down RCC flooring C, and kettle shed were found to be standing at the said location. My lords, the next point. And they were assumed to have been built before the land freezing notification. It says it has been assumed, whereas the interpretation by the learned arbitrator as per para number 7 is that they were actually standing before the freezing order.
Assumed to be standing.
So, my lord, if they were able to prove that their structure was constructed prior to 3A notification, then, my lords, we have nothing to say. That was why they have gone before learned arbitrator to prove that their structure was standing before 3A notification. But, my lords, they failed to prove that their structure was standing prior to 3A notification. And, my lords, as per the guidelines that I just referred before in the last, there are specific guidelines for Kala to include only those buildings that were there on 3A date notification, because there has been incidences where post 3A notification the landowner construct the building to enhance the compensation.
Yes.
And my lord, with respect to escalation of price, it has been done arbitrarily without any substance to how the figure has been arrived at. Also, the learned arbitrator has includes the other categories which were not even the relief before.
Where is the price rise?
My lord, at page 225, my lords, of the appeal book. My lords, para number 10.9.
We are for the non-residential area.
Yes, my lords.
What is the reasons given by the Kala?
My lord, para 10.9. Having considered all this critical assessment using the provision of the relevant act, analysis of judicial pronouncement elaborately discussed above, and in particular the most pragmatic proposition coming from the apex court in arriving at a price agreed upon between a willing purchaser and a willing seller in an arm's length deal, and the price which it would fetch in an open market would be the ultimate clincher, and they are the golden thumb rule. The market value of the land that would be reasonably suitable for the area is indicated below. Kala is to adopt these rates in the relevant cases.
It has to be case specific. How can it fix the rates for all over? Doesn't have the right.
And whatever figure has to be arrived at, there has to be some substance, how the figure has been arrived at. And the learned arbitrator is bound to comply section 26 of the Right to Fair Compensation Act 2013, which provides a clear procedure how the figure has to be arrived at.
Yes.
May it please your lordship. My lord, at the outset, I would like to submit that one thing which we must remember all the time, that my learned friend, the appellant herein, have no statement of defense before the arbitrator. Now, my learned friend has great points, but this court is simply not the arbitrator's court. All these arguments he could have raised before the arbitrator, but they chose not to do, even though they were participating there. They have waived their right entirely. And now, at the fact, and they are arguing upon issues of facts, supplying papers. Now, your lordship has been very lenient in allowing them to furnish this alia plan map. Now, regarding this alia plan map, my learned friend has been saying that the Kala left out the structures because of the alia plan map. What structures have been left out, my lord? Compensation, in our case, compensation has been given to 3 structures. That number is very important, 3 structures. What my learned friend is saying is that
Kala is given for 2 or 3?
3 structures. But in the LA map, while they are relying on the LA map only shows 2 structures. Even that is contradicting. If we are to even consider these...
No, LA map is made in 2021.
Yes, ma'am.
Yes. The reason why I'm saying this, my lord,
Yes.
they said the Kala left out these structures because it's not in the LA map. But when we look at the LA map, there are only 2 structures. It should have been 3. If their submission
It should
is
have
true.
been 5.
Yes, it should have been 5. Yes, correct. It should have been 5.
Then no, your case is that Kala gave you 2 and arbitrator gave you 3.
No. My case is
Or
that
is it
Kala gave 3, my lord.
Kala gave 3,
Kala gave 2.
arbitrator gave 5.
Arbitrator gave
Additional 2.
additional 2.
On the basis of this post
So
verification.
then, you're right. In that case, this LA plan should have 3 structures.
Yes, my
It
lord.
is, there are only 2.
So, my lord,
According
Kala
to-
has given them compensation for 1 additional structure also.
No.
Although, my lords, we have not challenged
No,
that.
no,
So, my lords, we are not also disputing the fact. my lords.
No. I don't think so. You see, your argument was sounding all very okay until it is being brought to this court's notice that the LA plan provides for only 2 structures.
That's true, my lords. Yes.
Then
My lords, they have already got compensation for 1 additional structure by Kala.
no, so we do not know about that. You should have brought that up. You should have gone in arbitration.
My lords, we are not challenging that. My lords, we are not challenging.
You did not even submit a written statement to the arbitrator.
My lords, we have not submitted, but Kala has submitted, my lords. And
Kala
we are
might-
relying upon the Kala submission only. We are not raising a new ground here, my lords. With regard to LA drawing, that is a submission of Kala.
So now they have brought out this. I cannot go into those facts. I thought you had some point now. Because if the LA plan has 3 structures,
My
then
lord, that's
it was
true.
okay.
That's true.
With regard to the rates, I don't think so. No case.
For us, my lord, let me try to convince your lordship, my lord, regards to the market rates. Now, yesterday, I have read out how the Kala inflated the market rates. Initially, before the arbitrator, we say that the market rates...
It inflated the market rate. The
Inflate
Kala
as in,
inflated.
increased.
Then, and then you want some more inflation.
No. Initially, our initial prayer before the arbitrator was that how the manner in which the Kala assessed the market rates is so unfair. It is so unfair, it should have been rupees 227. Yesterday, I had taken your lordship to how the Kala assessed the market rates. If I may take you to that portion again, my lord. Page 101 of the appeal memo.
Yes.
On the fourth para, my lord.
Yes.
Subject 2.
Yes.
Subject to the applicability of section 26 1B, 169 registered sale deeds have been identified for determination of market value of land belonging to a similar type of land in the proposed area of acquisition or near vicinity area. This part is very important. Sale deeds wherein structures are present at the time of execution of the sale deeds have been excluded. We are
Please,
so aggrieved
please
with this.
continue reading.
Yes. The location of the sale deeds considered in determination of market value of land include areas of Reng Tekon, Diakon, New Diakon, Kuang Pui Lam Tui Chaveng, Veng Lai, Eng Ting Dol, where the alignment is proposed to pass through.
The sale this, so
The sale deeds from the 8 village councils together are deemed adequate for determination of market value of land at the district headquarters, Kolasip town, under this project.
correct. For Kolasip,
Yes.
it is all right.
Yes.
That's what it's saying.
Yes.
Now your land is at Vairengte.
Our land is at Vairengte.
Now why should it be higher in value?
It should be higher in value because of what has been explained earlier, my lord.
Where
Vairengte is-
has been explained?
in Vairengte, my lord, before the arbitrator, when we went to the arbitrator, we brought sale deeds from
You
Vairengte.
see, the issue is not what you say to the arbitrator.
Yes.
The issue is what is the reasoning given by the arbitrator to enhance the rate. You see, you can say 1,001 things.
Yes.
He can say 1,001 things. Now, what is the decision of the arbitrator based on?
I will take your lordship.
Yes.
I will directly read the arbitrator's decision regarding this particular market rates, my lord. Page 225.
Yes.
Para 10.8. In the final analysis and considering the need for adoption of proper method of assessment of land value for determining prominent and developed settlement prime area in and around Kolasip is normally to be determined as per explanation to section 26 of the RFCT LARR Act 2013. Land acquisition for the National Highway 306 is in the area of bypass area, mostly non-settlement and virgin areas, which is away from the main prominent areas. It cannot be regarded as the most prominent locality to be bracketed with the highest market value. Owners of low-graded land are subjected to suffer more in a matter of 12 inches of land if it falls into the demarcation zone. The grading system is rationalized for simplicity and pragmatism, essentially to remove anomalistic classification to the detriment of some areas, though they are lesser than 5-kilometer distance to each other. Kala predominantly gave high factor to commercialization of the area. It is relevant to consider several other crucial criteria such as the agricultural garden farm in non-settlement areas, and importantly, Vairengte, Kolasip district is the gateway to the state of Mizoram, where CIJW school is established. Taxation and supply check gate and enforcement check gate and other government departments are set up. This was the reasoning made, my lord.
Mr. Counsel, that is a
Yes.
very good reason. But that has to be supplemented
Yes.
by way of sale deeds with regard to the market value of the land.
We have-
The arbitrator has to say, not you.
Okay.
Arbitrator has to say, what is the market value of the land at Vairengte? What is the market value of the land near the police check post or 5 kilometers away? That market area is not, you cannot just say, oh, that shop looks very nice. You know, the people working in the shop are so beautiful and good looking. So whatever they sell should be 20,000 rupees each material. You cannot say that. You have to give the rate. It's not what you perceive. It is just a perception of this arbitrator. That way, though, all along the route of, you talk about gateway to Mizoram, gateway that, all right, gateway, so what? It is the gateway. But no one stops there to bring in stuff. They all pass through and they walk and they go somewhere. That's not the issue. The issue is what is the rate. He has only talked about this and that. It is the gateway. This has not said anything about the rate. That's all.
Lordship is
So no
right.
case.
Let me fairly submit to your Lordship, my Lord. Initially, when this arbitral order was issued, even us, we were not that happy initially, because as I stated earlier yesterday, we have plowed our lands, used excavators, and we have been using our lands for godowns as businesses. And the rate which we expected was rupees 227. Now, the arbitrator increased it to rupees 15 from 85 to rupees 100. Now, we say it's okay, then we will accept.
No, you see, it's very simple. When the railway was coming in,
Yes.
I was offered land, personal experience. I was offered land. Someone told me, why don't you buy this for 18 lakhs? The owners told me. I looked at the plot of land, slope also, and I said, no, I'm not interested. So he couldn't sell. I believe that fellow was marketing his land for something. He couldn't sell. Award came, and you know how much he got for his land? 36 lakhs. Exactly double of what he had offered me. So what I'm trying to tell you is that the market rate actually is much less. All the acquisition rates are, everybody wants to sell, nobody wants to sell their land. They all want their land to be acquired because they get much more than what is the actual value.
That's very true.
That is the correct thing. No one is going to buy some land in some village somewhere for lakhs and lakhs. No?
And my lord, that's the reason why
That is
people-
why everybody wants their lands to be acquired.
Yes, absolutely.
Correct. My Lord.
So I have been a lawyer,
Yes.
and I have been a lawyer for the landholders. So I know, and I have been the lawyer for the landowners all over Mizoram. So I know. I was there in this other lot of cases. I was there.
Yes.
And all of them want their lands to be acquired. They don't want to sell. Selling, so they couldn't get buyers.
That's true.
So anyway, and out here, some reason has to be given. This is not the reason.
My Lord, I asked this myself. When I,
Enough,
when I,
Mr.
when I,
Council, we're wasting time now.
No, my lord. Just one last thing. Yesterday, I have shown your lordship that decision by the Honorable Apex Court saying that if two views are possible,
Correct. Out here, the view is, there's no view.
there is the view.
The view is, you see, is like this. Supposing you want to sell me some cold drink. Say, some cold drink, as you say, it's very sweet and very good. And you say it's 100 rupees or say 1,000 rupees. And then there is another, same colors being sold out there. And then then that fellow is saying that it is only 100 rupees. So how do you compare? And they say it's the same product. You say his is same as his also. So if it's the same product, how do you compare the prices? You compare the prices because I will know your rate, then I will know his rate, then I will say, okay, the real rate should be 100 if it's the same product. So that is, you make a rate, you make a decision on a rate after finding out the various rates. Out here, in your case, the arbitrator has not said that this 100 rupee land should be 120 because of some reason. Because the adjacent land was sold for 120, or this is the sale deed for 120. Nothing. He just said that it's very important land, gateway to Mizoram, so it should be 120. That cannot be, because Section 26 of the Act, of that 2013 Act, provides the manner in which you have got to make the assessment. So the arbitrator cannot cannot follow his own path. He has to follow the law laid down in the 2013 Act.
Correct, correct.
So that is the issue.
I completely understand, my lord.
Yes,
I
that's
completely understand that the arbitrator's order is not perfect. As a matter of fact, we had submitted to the arbitrator several sale deeds to the arbitrator himself, which we annexed in the arbitrator application proceedings, and which was unfortunately not.
We'll call for the arbitrator. Where is this? He has not mentioned one thing in his arbitrator award. What do you think can supposing this court, supposing this court has to decide as to what should be the price of some property. Can I just say it's in a beautiful location where everybody wants to be there, so it should be this, and the DC rate made on some sale deed cannot be applied. Can I say that? I cannot say that, because can I also say, then you will say, but what is the basis for you saying that? Where is the sale deed? So here also, if the arbitrator had some sale deeds which he could rely upon, he should have mentioned it here. If he had not mentioned it, then what to do? I do not know on what basis he has taken a decision. So that is why I have asked you from the beginning.
Yes.
You want me to send it back to the arbitrator, then I have to send it back wholesale. Wholesale means even the structure issue will have to be taken up. I have given my point of view, my thought process. I have told you where I am leaning.
Yes.
Now, I have given you a chance. If you want to send it back, I can send it back wholesale, or I dispose of the thing on the basis of what I see just now. That's all. It might not be in your interest to send it back also.
I will leave it to your lordship's wisdom.
Yes. So
Because
I've heard you. You're not going to change my mind now. That's
Yes,
the thing.
yes. I will leave it to your lordship's wisdom. One thing which I myself ask, should we have a microscopic judicial view of the arbitrator's order?
Mr. Counsel, it is not a microscopic view. There is no reason. When there is no reason, where is the question of microscope? It is on the face of the thing. Microscope means when you go behind and see the evidence. I am not going behind. I am not seeing the evidence. I am seeing the order. I don't see any finding based on any sale deed. No rate is mentioned by him. He just talks about how beautiful the Himalaya is and what not. How does that matter? Okay, right.
One more.
Heard.
My lords, one more submission.
Yes.
My lords, with respect to the reasoning has to be there. My lords, the 34 court has not given any reasoning with respect to the inclusion of structure. There's no reasoning before 34, my lords. He has not given any reason
It's okay.
to uphold the award of learned
So
arbitrator.
he is upheld. So what is wrong?
They have
You have not challenged. You have not challenged the. You have not. You see, the thing is that your very basis for challenging
LA plan.
that structure is gone.
Yes.
I'm not
that's
going to
right.
go beyond that.
Okay.
I was giving you a chance to show me. That's all.
I'll leave it to
This,
your
with
lordship.
regard to the rates, there's nothing in the face of the order. There's nothing in the face of the order. Right. Heard. Mr. Kartik Jain, learned counsel for the appellants. Also heard Mr. Alred,
Zoltan Moya,
learned counsel for the
private respondents.
private respondents. No one appears for the respondent number
2 minutes.
2.
Kala.
As a private respondent,
Respondent.
for the respondent number 1. No one appears for the respondent number 2. Right. The appellant has put to challenge no, the appellants. The appellants have put to challenge the impugned judgment and order dated 17-10-2025 passed by the Additional District and Session Judge Colasi, by which the appellant's appeal against the arbitral award dated
14/6/2024
14/6/2024 under Section 34 of the Arbitration and Conciliation Act, 1996, hereinafter referred to as the Arbitration Act, wide arbitration petition number 8 of 2024 has been dismissed. The appellant's case is that the land of the respondent, number 1, covered by, what is it?
periodic
Periodic patta number
my lords 501501
501/501/10/2008
/2008/2004
had been acquired under the National Highways Act, 1956, hereinafter referred to as the 1956 Act. The respondent number 2, bracket Kala, wide award dated
12th May 2022.
12/5/22,
Yes.
issued under 3G of the NH Act, provided for payment of compensation for the acquired land, including 3 structures that were standing on the land of the appellant.
Land of the respondent number 1.
Of the respondent number 1, sorry. The next para, the appellant, now the respondent number 1 was aggrieved with the market rate for compensation of land made by the respondent number 2. And also with the fact that the respondent number 2 had provided compensation for only 3 structures on his land. Though there were 5 structures according to the respondent number 1. Next para. The respondent number 1 thus paid for arbitration proceedings to proceed in terms of Section 3G bracket 5 of the NH Act, praying for enhancement of the market value of the land and for including the 2 additional structures on his land for payment of compensation. The learned counsel, the next para, the learned arbitrator, thereafter passed arbitral award dated
14/6/2024
14/6/24 by enhancing the market value of the land of the respondent number 1 from rupees 100
from 85 to 100.
From rupees 85 to 100 per square feet. It also allowed the prayer of the respondent number 1 for inclusion of the two structures which were absent, which did not find mention in the award made by Kala under section 3G of the NH Act. Full stop. Next paragraph. The appellants, being aggrieved with the enhancement of the market value of the land by the learned arbitrator, by and the inclusion of two additional structures for payment of compensation by the impugned arbitral award dated what?
14/6/2024.
14/6/2024, comma, submitted an application under section 34 of the Arbitration Act before the
Additional District and Sessions Judge,
court of the additional district and session judge, comma, Aizawl district, comma, Kolasi. Full stop. The same was registered as arbitration petition number 8 of 2024. The learned civil court thereafter.
8 of 2024, my lord.
That's what I said.
Yes.
Full stop. The learned civil court thereafter, while judgment and order dated 17/10/2025, dismissed the application under section 34 of the Arbitration Act by holding that the enhancement of market value of land belonging to the respondent number 1 had been done by taking into consideration the prevailing market value of the land within the district based upon relevant sale deeds, comma, the location, comma, inflation of prices, comma, which was found reasonable. What about the structures? It did not make a
My lords,
mention.
that's what I was trying to bring before your lordship, has not gone into the issue about structure. Although he has recorded all our submission in the foregoing pages, but has not given any reason why those structures should be included and the award should be upheld on that issue.
But again, my lord, the fact still remains they did not raise those contentions before the arbitrator.
No, but the appeal is there. Once the appeal is there, full stop. However, the learned civil court did not make any discussion or finding with regard to the learned arbitrator awarding compensation on the two additional structures in the impugned judgment and order dated 17/10/2025. Full stop. It should have taken a decision either way, this way or that way, or rejected. Anyway, right. If we go back, everything gets delayed. If we send you back, everything gets delayed.
Correct, correct.
Next para. They'll go to Supreme Court.
Most probably, I think so.
Next. What Supreme Court will see? The appellants being aggrieved by the impugned judgment and order dated 17/10/25 passed by the London Civil Court in arbitration petition 8 of 2024 have filed the present appeal under section 37 of the Arbitration Act. Next para. The learned counsel for the appellant submits that a notification under section 3A of the NH Act was issued on 21/5/25. On 21/5/21.
Yes.
On 21/5/21. While the award under 3G had been made on 12/5/2022. He submits that the award had been made on the basis of the land acquisition plan (final) drawing and schedule dated, there's no date.
Let's date it 1/10/2021.
Dated,
1/10/2021.
where do you get one? Where do you get one?
It's the LA drawing which I have submitted. On the bottom of the page, left side, it is written date.
Dated 1/10/2021. In the said drawing, there are two structures mentioned therein in the land of the respondent number 1. As such, as the manual, as inverted commas, a manual of guidelines on land acquisition for national highways under the National Highways Act, 1956, inverted commas close, provides at clause 10 bracket Roman 4 small that market value of land is to be determined as on the date of publication of the preliminary notification under section 3A of the NH Act, any improvements undertaken over the land notified under section 3A after publication of the notification in order to enhance the quantum of compensation was to be ignored by Kala. Full stop. He accordingly submits that when the land acquisition plan dated 1/10/2021
21.
did not show structures beyond, it did not show beyond 2 structures on the land of the petition. There was no justification for either the respondent number 2 or the learned arbitrator to have awarded compensation for more structures than what was provided in the land acquisition plan. How do you say that KR is a structure?
My lords, at the left-hand side top, there is a full form of KR which says Kacha residence.
Next. He accordingly submits. No, next para. The learned counsel for the appellant further submits that the enhancement of the compensation for land from rupees 86 per square feet to rupees 100 per square feet by the learned arbitrator
From 85 to 100.
from rupees 85 has been made without any basis. There is no determination made by the learned arbitrator in terms of section 26 of the right to fair transfers against 2013 Act. No. To have enabled him to enhance the compensation amount. The same being a patent illegality on the face of the order, on the face of the award, under section 34 bracket, on the face of the patent illegality, comma, the same should be. Under section 34 bracket 2 capital A, bracket close, of the Arbitration Act, the same as the enhancement of the market rate, the enhancement of the land value. Is not sustainable. He accordingly submits that the impugned arbitral award dated 14/6/24 and the impugned judgment and order dated 17/10/25 passed by the Court of the Additional District and Session Judge, Aizawl Judicial District, Kolasi, have to be set aside. Full stop. Next paragraph. On the other hand, the learned counsel for the respondent number 1 submits that the appellant has not made any challenge to the decision of award made under 3G of the NH Act, wherein wherein compensation has been given for 3 structures on the land of the respondent number 1, comma, besides the compensation rate given for the land. He also submits that no written objection or affidavit has been filed by the appellants before the learned arbitrator. With regard to the prayer made by the respondent number 1 for enhancement of his compensation amount and for payment of compensation for additional 2 structures, which has been left out by respondent number 2, Kala, in his award made under section 3G. The next paragraph. The learned counsel for the respondent number 1 further submits that proper reasons have been given by the learned arbitrator for enhancing the award, for enhancing the compensation payable for the land, I have heard the learned counsels for the parties. There are basically 2 issues to be decided. The first issue is as to whether the learned arbitrator could have granted compensation, awarded compensation for the 2 structures which were not a part of the award under section 3G of the NH Act. Secondly, whether the learned arbitrator could have enhanced the land value of the respondent number 1. Land value / market value. Land / market value. This is nowhere a part of the documents.
Unless this is spot verification report?
Yes,
Yes, it was a part of the record before learned arbitrator, my lord.
it was a part of the record.
This spot verification happened because of his interim order, my lords. Learned arbitrator has passed an interim order. Thereafter, this spot verification was conducted.
Next paragraph. During the what is discernible from the submissions of the counsels for the parties and the documents is the fact that a spot verification was conducted pursuant to an interim order passed by the learned arbitrator in arbitration case number NH-306/KLB/18/ARB-2023 with regard to whether there were 5 structures on the land of the Respondent number 1. A spot verification was conducted on 14/3/2024 in the presence of Mr. Saksham Tyagi, in the presence of a representative of the appellants, the government, the village council, and the landowner.
The spot verification was conducted on 14th March 2024.
Yes, yes.
The report
Okay, where-
comes on 14 May 2024.
Okay. On verification 14/3/24. Huh? And the report says, and the report dated 9/5/2024 states at para 5, 4, 3 and 4 as follows. 3, 4 and 5 as follows. Huh? I'll just mark it 3, 4, 5. Okay. The learned arbitrator, next para, the learned arbitrator in his arbitral award
Page 220.
thereafter held at para 7 as follows. Page 220. Next. Though there appears to be some ambiguity with the spot verification report and the arbitral award, in as much as the spot verification report states that the 5 structures were assumed to have been built before the land freezing notification under Section 3A of the NH Act, the arbitral award states that the 5 structures were actually standing before the freezing order and that only 3 structures were assessed and compensated. The above is a disputed question of fact which has been answered by the learned arbitrator. Full stop. There is nothing in the land acquisition plan dated 1/10/2021 showing that there were 5 structures or even 3 structures standing on the land. However, the respondent number 2 had awarded compensation for 3 structures in the award made under 3G. The above clearly shows that the land acquisition plan was not accurate. Full stop. As such, it cannot be said that the land acquisition plan made on 1/10/2021 had listed out all the structures that were on the land of the respondent number 1. system. Though there is some ambiguity as to when the structures were really, as to whether the structures were there at the time of the freezing order made under Section 3A of the NH Act, comma. The learned arbitrator having taken a decision on the said issue and keeping in view that there is no certainty, keeping in view that the land acquisition plan cannot determine whether, cannot be used as a determining factor as to whether there were 5 structures standing on the land of the respondent number 1 at the relevant point of time, comma. The view of the learned arbitrator would have to be accepted by this court in terms of the judgment of the Supreme Court in the case of
Ramesh Kumar Jain.
in
First-
in the case of
Ram-
para
Para 34, 35,
no
and Punjab State Civil. That
keeping in view the judgment of the Supreme Court in the case of Ramesh Kumar Jain versus Bharat Aluminium Company Limited bracket Balco SLP C number 14529 of 2023, wherein it has been held that if there is some evidence, comma, even a single witness's testimony or a set of documents, comma, on which the arbitrator could rely upon or has relied upon to arrive at his conclusions, comma, the court cannot regard the conclusion drawn by the arbitrator as patently illegal merely because that evidence has less probative value. This thin line is crossed only when the arbitral tribunals, only crossed when the arbitral awards, the arbitrator's conclusion cannot be reconciled with any permissible view of the evidence. In the present case,
My Lord, regarding that issue of whether 2 views are possible. Punjab State Civil Supplies, para 12, 13, and 14.
Further, in the case of Punjab State Civil Services, Punjab State Civil Supplies Corporation Limited and other versus MS Sanman Rice Mills and others, SLP C number 27699 of 2018, comma, the Supreme Court has held that if 2 views are possible with regard to wherein the Supreme Court was to decide an issue pertaining to an arbitrator's award under the Arbitration Act, comma, the Supreme Court held that even if 2 views are possible, comma, there is no scope for the court to reappraise the evidence and to take the different view other than that has been taken, other than that taken by the arbitrator. the view taken by the arbitrator is normally acceptable and ought to be allowed to prevail. Full stop. Next paragraph. Keeping in view the fact that the basis for the appellant's challenge to the award of compensation to the additional two structures is based upon the land acquisition plan, which does not show the correct picture of structures standing on the respondent number one's land, comma, and the fact that the spot verification report dated 9/5/24 shows that 5 structures were standing on the land of the respondent number one. We do not intend, this court does not intend to interfere with the decision of the learned arbitrator or the learned arbitrator in awarding compensation for the additional 2 structures. Full stop. Next, with regard to the question of enhancement of the market value of the land of the respondent number one from rupees 85 to rupees 100 per square feet, comma, the learned arbitrator in paragraph, where is that word? This page
225.
It starts from 224, my lord. 10.4. Determination of market value of land.
The learned arbitrator in his arbitral award has basically given the manner in which the rates of the market rates of lands have been fixed in the village of Vairante, Bilkotlir, Konpui and Bolpui. Correction order, come on, la pechuach so recall look, so Vairante, it's a village, not a town. Vairante is not a town, no, it's a village. Vairante is a village, it's not a town.
It has been put in a category of town for.
It has been put in the category, but it's a village actually. But just that clarification, that order, I'll just clarify that part because it's not a town. It's a out here. It says arbitrator is saying this is a village. In the village of Vairante, Bilkotlir, Konpui, and Bolpui. No. What have I said? Has been fixed? No, it has been fixed. It has been fixed. Has been fixed. Has given the manner wrong. Has been fixed. Land of the respondent number one has been fixed. The manner in which the land of the respondent number one has been fixed. The learned arbitrator has also spoken of Section 26 of the RFC TLARR Act, comma
Lord, I'm-
2013.
My Lord, I'm sorry. Um, I, I believe that Vairengte is a notified town.
Okay, notified time.
Yes.
Okay, then it's okay. No difference.
Yes.
Doesn't make a difference. Full stop. The after stating all the above, comma, the learned arbitrator in para 10.9 of the award dated 12/5/22 has held that the respondent number one's land should be enhanced, the market rate of the respondent number one's land should be enhanced from rupees 85 to rupees 100. Is in Vairengte, in a non-residential area of Vairengte and adjacent to the national highway, correct?
Yes, ma'am.
Correct.
And adjacent to the national highway. Full stop. Wherein, full stop. It is interesting to note that the learned arbitrator has also enhanced the residential / habitat area / developed area of Vairengte from rupees 106 to 120, and the non-settlement area of Vairengte, no need, from say 106 to 120, without the same not being an issue at all before the learned. Without there being no reference with regard to the said issue before the learned arbitrator. It has, however,
My Lord, one thing I would like to.
it has, however, not touched the market rate of the non-settlement area of Vairengte, which is at rupees 64. Yes.
My Lord, I believe the arbitrator also adjusted the residential area because of the way how it has been decreased. May I take you to
But
page
this
number
is not.
102?
This is your award, Mr. Counsel.
Yes, yes, correct, correct.
This is your award. This is not. No other person is supposed to be in this award.
Correct, correct.
He cannot. In your award, he cannot put in some other person's case.
May I show you, my Lord, page number 102?
Why? For what?
Because the rates have been decreased 20% from serial
It
numbers.
may be correct,
Yes.
but your case is not with regard to the habitat area.
Hmm.
Your case is not with regard to the residential area. So why should he touch upon that?
All right.
That cannot be. Right. Next. A perusal of the above finding and discussion of the learned arbitrator as the basis for enhancing the market value of the respondent number one's land clearly shows that no sale deed market rate, specific market rates, and documents with regarding to rates of lands in the adjacent areas have been discussed. There has to be a discussion on the specific rates of the areas adjacent to the land of the respondent number one, which is conspicuously absent. The absence of reasons for enhancing the land, the market land, is not at all visible in the face of the arbitral award. There can be no two views with regard to the fact that there is no discussion or finding made by the learned arbitrator. There can be learned arbitrator in his arbitral award that the specific rates of adjacent or adjoining lands had been discussed. Adjacent or adjoining lands in Vairengte had been discussed, which could be there in some sale deed or document for enhancing the market rate of the respondent was land. This court is next para. This court is well aware that the scope of interference with arbitral proceedings or award is very limited and has to be confined within the ambit of Section 34 of the Arbitration Act. However, as held by the Supreme Court in the case of so and so, I'll continue. Basically, I'm setting aside the arbitral award. You just write the last part. In view of the above reasons, the arbitral award dated 12/5/22. Arbitral award dated
14/6/2024.
14/6/2024 is set aside to the extent that, only to the extent that the market value of the land of the respondent number 1 has been enhanced from rupees 86 to rupees 100. The challenge to the award of compensation for the additional 2 structures by the learned arbitrator, however, fails, and the arbitral award providing compensation for the 2 additional structures on the land of the respondent number 1 is not interfered with by this court. That's all. I'll continue later.
Deeply obliged.
Deeply obliged.
There'll be some minor corrections here and there I'll have to do.